Thank you very much, Kathy, and it's a pleasure to be with all of you. For those of you here on the East Coast, it's a little bit afternoon, and for those of you tuning in elsewhere, we're glad you can be with us. It is just about Thanksgiving, of course, and we are looking forward to bringing you a terrific program. Even though it's a little bit rainy here in New York City, and it may make for a soggy Thanksgiving Day parade. There's a lot to look forward to, and we hope that, of course, all of you have joyful times with your family and loved ones over these coming days. Why don't I turn to the agenda so that I can walk everyone through what we intend to cover today? Thank you, Kathy. So I will, after walking through this slide, provide a brief update to you on some activities at the legislative level in New York State, well, in specific, with bills that the executive, Governor Hochul, hasn't signed, and we will talk about that momentarily. And then we will have Christopher Cruz Sierra. Chris is an associate in our New York City office. Excuse me. He's been on the program before, and Chris is picking up the baton, as it were, on congestion pricing. We've had some other presenters on this topic previously. We want to give you updates because as we move into budget season, it's very relevant that congestion pricing is back on the table. So more to come from Chris. And after that, we will be hearing from an attorney with bond who sits in Florida, in Naples, Jeanette Lombardi, who has been on our program before, and we're delighted to have Jeanette back. And Jeanette's going to be talking about the Florida Community Property Trust Act and its applications, not just for Floridians or Florida residents, excuse me, but for all of you. And so we want to make sure that you have an opportunity to hear about that from Jeanette. Then Patrick Caldarelli will be speaking thereafter. Patrick is also an associate in our New York City office, and he's going to be addressing the New York State Department of Labor's guidance on protecting outdoor workers. There were two companion pieces that came out recently, and we thought it was worth everyone's opportunity to learn more about that. So Patrick, thank you for carrying that. And then the last presenter of the program today will be Kim Walcott-Agrade, who has not presented on the program before. Kim has also passed the bar, and we're delighted about that. And she'll be under my supervision, however, because she's not officially sworn in, but has been doing wonderful work for the firm. And we are delighted to hear what she has to say about the Department of Labor's, it's a federal enforcement of coercive contractual provisions that essentially are, ones that, the current DOJ has taken an interest in, as Kim will get to, and I don't want to, get ahead of her. It'll be interesting to see what happens in the new administration where some of these standards are changing. But for now, let's get to the slide that follows, please, Kathy, and I can go through what's happening in New York State. And if you would advance one further, please, that would be terrific. So what I want to make sure all of you are aware of is that, we are getting to bill signing season. This is the time of year where in New York State, Governor Hochul is considering those bills that have been, brought forward to her. In the past, we've talked about the process and the legislative dance, as it were, in terms of when bills get to the governor's desk. Without going into those details right now, in the interest of time, it's just worth noting that in the last short interlude, we've seen the governor sign bills around gym memberships, telemarketing, sanitation in restaurants and the transparency thereof, labeling of over-the-counter pharmacy items, and then she vetoed, interestingly, a bill concerning agency reporting to the state controller on late contracts, specifically referring to not-for-profit organizations and a nexus there. So the activity is beginning. But if you go to the next slide, what we know is, and thank you, Kathy, there are a lot of big bills that haven't yet gotten to the governor for consideration or signature. Among them, the Grieving Families Act, which has come around a few times. We've talked about it here on the program before. The Climate Change Superfund Act, lithium-ion battery safety, and others there, including the Fashion Workers Act. Just know that as between Kristen and me, we will make sure to give you coverage as we can in terms of legislation that does get signed into law and what gets vetoed as we close out through December, and certainly we will tie up loose ends in January where necessary. But for now, that's all we have on that issue. But in related matter, it's important, as I was mentioning, to keep you all apprised on what's happening with congestion pricing. Of course, you all remember that this had been approved with $15 per hour. And what we at that point were quite confident on was that we were going to see some major changes in New York City. And all of a sudden, then we weren't. The governor halted the program. And so what I hope that we can discuss, Chris, with your help, is where things stand currently and what kind of difference this will be both for the day-to-day experience of New Yorkers and how it ties into that ongoing budget process that'll be around the corner in New York State. So, Chris, the floor is yours. Thank you very much.
Absolutely. Thank you, Gabe, for having me today on the webinar. Happy to be here, tuning in from Florida, by the way. So really sunny outside, beautiful day. But like Gabe said, this is very important, not only for those who live in New York City or those who commute into the city, but also for those outside of the city that live in other areas of the state. Again, this impacts the state's budget. And with the reduction, which I'm going to get into in a little bit, but with the reduction in toll prices, it's left sort of a hole in different areas within the state's budget for next year. So this is quite important, and negotiations are still ongoing. So we'll see how the reduction in toll pricing impacts the overall budget. Next slide, please. But just to provide a little bit of background on the congestion toll pricing, on April 1st, 2019, the New York State Legislature enacted the Traffic Mobility Act, which directed a congestion tolling program for vehicles entering the Central Business District, which is the area south of 60th Street in Manhattan. And the toll aims to reduce congestion within that area and also pollution in Manhattan, while generating revenue for public transportation improvements, not only within the city, but in other areas outside of the city. As Gabe mentioned, on June 5th, 2024, Governor Hochul halted the congestion pricing plan for a few weeks, just a few weeks before the program was set to launch. And she was concerned about the impact the toll was going to have on working class New Yorkers with the $15 toll. Next slide, please. Now, there is a new plan that's going into effect on January 5th. The plan has been approved by the Federal Highway Administration, and this just came out of the hot press on November 14th, 2024. And according to the governor's office, the new program is more affordable for New Yorkers. And I'm going to go over the program in a little bit. But a lot of critics are saying that the new program was implemented rather quickly. And the thought is that the governor's office is a little bit concerned with the incoming presidential administration, because they have been very outspoken about their opposition to the toll within New York City. Next slide, please. So here is the current plan as it stands, again, to go into effect next year, January 5th, not too long from today. But as you can see in the picture, this is where the different tolls are going to be located, different entry points across the city. It's kind of sectioned out by daytime tolls and nighttime tolls, but for the daytime, it's going to be anywhere between 9 a.m. to 9 p.m. on weekdays, and from 9 a.m. to 9 p.m. on weekends. For passenger vehicles, those are going to be tolled once per day at $9. So originally it was $15, now it's going to be $9. For motorcycles, again, once per day, and the new toll here is $4.50 once per day. For trucks, it depends on the size of the truck, and it can range anywhere between $14.40 to $21.60. Now, the guidance that's posted on the governor's website does not indicate whether trucks are going to be tolled once a day or multiple times, so that should be coming out pretty soon. For tunnel crossing, it was decreased by 40%, and it is now $3. For off-hour tolls, so not within that 5 a.m. to 9 p.m. on the weekdays, it's 75% less than the original price. Now for app-based ride shares, so we're looking at Ubers, Lyft. We're looking at an additional $1.50 toll or addition to the price that would typically take to travel from one area to another area. For taxis and black cars, that's 75 cents. Now there are areas that are not going to be tolled. So if you're just driving across FDR or driving on the West Side Highway, there is no tolls on those areas if you're not entering to that red zone that's listed here in the picture. Next slide, please. There are some exemptions, and those were carried from the previous plan. For example, the emergency vehicle exemption. There's another for specialized city vehicles, public transit buses, city school buses, and there is a qualified disability exemption that will apply to certain individuals. And there's also a discount for low-income individuals. The discount is 50% for the daytime rate after the first 10 trips. So those individuals will pay $9 for the first 10 trips into the red zone, and after that it'll be $4.50. Next slide, please. Now, according to the governor's office, individuals will see new and improved subway services as a result of the revenue that will be gathered from the tolls. They have a plan to extend the 2nd Avenue subway up to East Harlem. Individuals will see investments to the Long Island Railroad, the Metro North, more elevator services for senior and people with disabilities. There is a proposed expansion of electric buses and plans to build an interborough express from Queens to Brooklyn, which would decrease commuting time by 30 minutes. That's the current plan. This is what individuals would see with the revenue from the tolls. Next slide, please. Now, of course, there are some legal challenges. I'd like to just kind of go back a little bit. After Governor Hochul halted the program back in June, two advocacy groups sued the state, indicating that she did not have the authority to halt the toll. So those have been settled as a result of the new plan, but given the current state of those individuals or the lawsuits that were brought against the tolls, we don't know what's going to happen to those 2 lawsuits that were brought after June. So right now there are approximately 9 pending lawsuits against the toll pricing, and 2 specifically are in front of Judge Lyman from the Southern District of New York. They have until those 2 advocacy groups have until November 29th of 2024, so in a couple of days, to make their case for preliminary injunction to stop the tolls from being implemented on January 5th. And after the November 29th date, there is a hearing date for December 20th, 2024, where parties on both sides of the issue will present their case to the judge, and the judge will issue a final decision as to whether the toll pricing is constitutional or the many other issues that are in front of the judge. There are some environmental issues and health risks that the judge will also take into account. And so what we'll do on our end is keep track of the pending litigation and provide updates as they come about, because we know that this is an issue that, again, not only impacts us who live in the city, but also those who live outside of the city. Thank you.
And thank you very much, Chris. Appreciate the helpful summary. It's certainly going to come down to the wire with some of this active litigation, and we will keep all of you apprised. And again, thank you, Chris, for taking the time to provide this update. Let's move to our next presenter, shifting to Florida, or a different part of it, as it were, with Chris on his way to a family gathering, with the holiday. We have a full-time Florida resident with us, and that is Jeanette Lombardi, who is with us from our Naples office. We are delighted to have Jeanette back with us on the program. Jeanette has offered guidance to all of you before and may be familiar to you as a result. And this time is here to talk about the Florida Community Property Trust Act. And Jeanette and I thought we would handle this presentation a little bit distinctly, in that I'll ask Jeanette a few questions about it in real time and join her in this presentation, but we'll be guided by Jeanette's wisdom on the topic. This is an area within her trust and estates practice, which she is quite knowledgeable about, and thought it would be worthwhile for all of you to hear more about. So why don't we start, Jeanette, with what is the Florida Community Property Trust Act?
Well, thank you, Gabe. The Florida Community Property Trust Act was enacted in July of 2022, and it seeks to provide a vehicle where a married couple can create a joint trust and thereby provide that the property held in that joint trust be deemed community property. So Florida is not a community property state, and this would be a very simple vehicle to create that status of community property for the assets held in the trust. For example, if you live in Florida and you're married and you own a vehicle and it's titled in your name, you will be deemed to be the sole owner of that vehicle. On the other hand, if you were living in a community property state and you're married and you own a vehicle and it's titled in your name, that vehicle is deemed to be owned 50-50 by each spouse. So this statute, this act, creates a vehicle for holding property intentionally as community property, even though the state itself is not a community property state.
That's really interesting, and thank you for highlighting that. And as we think about the implications of what this affords, why would someone want to convert the status of property to community property in the first place?
Well, there is some income tax planning that can be created through this vehicle of the joint trust that has community property in it. So under the Internal Revenue Code, if you own community property and you pass away, there is going to be a step up in basis on all of the appreciated assets that are community property, whether or not it's held by the spouse who died or by the surviving spouse. So if you have highly appreciated assets or assets that might become highly appreciated in the years to come, it allows this additional planning where there's going to be this full step up in basis, so to speak. As an example, if you have a husband and wife who create a joint trust and they each contribute $10 million, and this is highly appreciated assets, upon the first to die, the 20 million, the collective property that is held in that joint trust is going to get a step up in basis, not just one half. So conversely, if you didn't have it in a community property status type of trust, or you didn't live in a community property state, and you had a joint bank account of 20 million titled as husband and wife, and one passes away, only half of the value of that account would get a step up in basis. So there is a lot of appreciation to be captured, stepped up to the date of death value, and it wipes out the capital gain and the capital gain tax.
Really interesting. And as I think about this a bit further, I'm wondering, for those listening now, where light bulbs may be going off, are there mandatory requirements in creating this kind of trust? I.e., if someone's thinking about doing it, what do they
Yes.
need to do now?
Well, there's 4 requirements. I mean, the statute has a lot of provisions, but there's 4 mandatory requirements. The first one is that the settlors, the people creating this joint trust, must be married at the time of creating the trust, and they both must sign the trust. The second requirement is that the body of the trust, the language, expressly state that it is intending to hold the property as community property. You can easily also draft that only a portion or certain assets would be deemed community property, other assets would not. However, that wouldn't make sense because the intent and the objective is to get the benefit of this Internal Revenue Code section on community property within this joint trust. The third mandatory provision is that there must be a trustee who is a qualified Florida trustee. And the statute defines that as either an individual who is a Florida resident or a bank or trust company that has Florida trust powers and can serve as a trustee. So if one or both of the settlers are Florida residents, that's pretty straightforward because the settlers can be their own trustee. However, if they are not Florida residents, more on that later, then they can actually hire a co-trustee and they can still remain trustees. If they don't want to deal with being a trustee at all, then they can simply have the qualified Florida trustee serve. And that is required for the duration of the community property status. So if at any point in time there isn't a Florida qualified trustee, then another one must be appointed so that it does not breach this provision. And lastly, there has to be a specific language on the front page of the trust that is a disclaimer or a warning that the settlers, the people creating this trust, the spouses, need to be aware that they should have independent counsel, or they can waive independent counsel, but they are basically stating that they are aware that there are some risk associated with the provisions of the act and creating the trust within the act.
Could you tell me a little bit more about those risks, please?
Well, there are basically two real risks, and then a third one, which I don't think is a real risk. The two risks that are involved are creditor issues. This type of trust, whether it's revocable, which is what I usually prepare for my clients and what I would probably recommend, because in that fashion, it can be amended and restated as often as the clients wish, or it can be irrevocable, which means it will not be easily amended or revoked. But it's not a creditor protection vehicle. It's an income tax planning vehicle. So if one of the spouses has a creditor issue and they didn't even contribute the assets, but they're deemed a 50% owner, the risk is that the creditor of the debtor spouse could access the assets for attachment in a court proceeding and collect from the assets of this joint trust. So typically, clients that are looking to prepare this type of trust for their estate planning and income tax planning don't have creditor issues, but it's a warning and it needs to be provided. And the other risk is very similar. It's divorce. So basically, the trust and the statute will provide that everything that is contributed to the trust, regardless of which spouse contributed the assets, will be deemed 50-50 ownership. So in the event of a divorce, that is what a divorce court must order, the 50-50 split. So there is that risk if it's not a long-term marriage, or if there's a prenuptial or a postnuptial agreement that might be contrary to this, then the clients need to understand that and maybe work around that. The third risk, which is not a real risk, is that if this is a brand new statute to Florida, and we here at Bond have done research, and we have found that there is nothing out there that would lead us to believe that the statute would not be respected. We have found that there have been other states that have enacted similar statutes in the past, and the Internal Revenue Service has respected it. But that potential risk is that at some point, the Internal Revenue Service might attack it and say, this is not something that we're going to respect. This is really not community property. In that event, then you go back to the 50-50 ownership, but only 50% would get the step up in basis. So it's really, there is no penalty associated with that. It would just be that the full step up in basis would not be available. Again, there's nothing on the books. There's nothing that we have found that would lead us to that conclusion, but it's just good to be aware.
Great. And this has been so instructive. One last question. As you know, there are many who are listening in who are not Florida residents, but may be interested in learning more about it. How does this affect them? How would they engage with this opportunity?
So if they have the ideal situation where they have highly appreciated assets or assets that they expect will be appreciating quite rapidly, it would be beneficial for them to discuss this with a trusted attorney and see if they have what might be ideal to prepare this kind of trust, because really you don't need to be a Florida resident. In fact, the statute specifically states that you just need to have a qualified Florida trustee and some type of nexus to Florida in order to avail yourself of this type of trust.
Really interesting. And so with that, I hope that if anyone wants to learn more, they can contact you. I also want to make sure that the audience is aware that you've written about this topic as well, and we will make sure to circulate that article, whether on the website where we post the slides for today, or otherwise in email communications. But this is really terrific. Jeanette, thank you for coming on and offering the audience some insight from your perspective as a Floridian, as an attorney focusing on trusts and estates, and we would love to have you back on a future program. Happy Thanksgiving.
Thank you. Same to you.
Great. And so let's move to our next presenter, please. And that is going to be Patrick Caldarelli. Patrick is with us from our New York City office. So we are shifting back to Midtown Manhattan, as no doubt all of you can see behind Patrick. And what Patrick is here to talk about is guidance on protecting outdoor workers issued by New York State's Department of Labor in essentially two different tranches. Patrick, by the way, is a New Yorker, as I am, grew up on Long Island, and Patrick's going to talk about this work, and we're also very delighted that Patrick is on the program for the first time. We hope this is the first of many appearances, and Patrick, we look forward to your presentation. Thank you so much for taking the time.
Thank you, Gabe. Hello, everyone. New York is looking to protect outdoor workers in regards to extreme weather, specifically exposure to wildfire smoke, extreme heat, and extreme precipitation, which includes both rain and snow. We can move on to the next slide, Kathy. So what is New York's goals in creating these guidances? And I should specify that these are just guidances. There is no mandate or law here. These are recommendations from the Department of Labor to keep employees who are working outdoors safe. So if you look at the quote from the commissioner of the DOL, she specifically references climate change and the potential impact that might have on the frequency of intense weather or extreme weather, especially wildfires and perhaps more intense hurricanes going forward. And if you look through the guidance, you see particular emphasis on having a plan before, during, and after the extreme weather event. So certainly having a plan in advance of something like wildfire smoke exposure or potential hurricane, implementing that plan and adapting that plan during that extreme weather event, and then following that extreme weather event, revising your plan, finding out where the faults were, what worked and what didn't work, and adjusting that plan for the next event. And in terms of the benefits for employers, the Department of Labor notes that if you implement certain policies and their recommendations, that you'll have fewer workers' compensation injuries, that'll improve your overall insurance costs. You'll have people taking time out of work less frequently due to those injuries, which might result in increased productivity. And next slide, please. So first, protection from heat. This is actually an older guidance from the late summer of this year. And specifically, New York lays out 4 steps, 4 recommendations for complying with these guidelines. Number 1 is providing 32 ounces of drinking water per hour and providing those employees the opportunity to actually drink the water, and have your supervisors encourage employees to stay hydrated throughout the course of their shift while working outdoors. Second is allow for rest and relief, which is a collection of potential options and categories. It's providing more frequent breaks depending on the temperature using the heat humidity index. So a combination of those 2 factors rather than just the raw temperature, say in Fahrenheit, understanding that if there's increased humidity, it's going to take a greater toll on the people who are working outdoors. So that's more frequent breaks, potentially altering an employee's work schedule to accommodate the extreme highs during the day. If you can schedule work earlier in the morning as opposed to during the hottest point of the day, during the middle of the day, exploring that as an option. And then if it's possible to completely change the work location, if you have a project, you can start where the employees are in shade, starting that project earlier in the week, if it's potentially going to cool off later in the week. And then there's the ability to provide your employees protective equipment. That could be hats, cooling vests, sunscreen, if there's no way to provide them shade throughout their workday. Next is to develop and provide training and some kind of policy where the employees are aware of those other options that they have. So if they have the option to take more frequent breaks, having a policy and informing them that if the temperature exceeds, for example, and this is laid out in the guidance, exceeds 100 degrees Fahrenheit on the heat humidity index, that they're entitled to 1 paid 15-minute break per hour. So they're only working 45 minutes in a traditional work hour if the temperature has exceeded 100 degrees based on the humidity. And then in terms of developing and providing the plan, it's actually writing out that plan so the employees know in writing that they have the option to take more breaks, assuming you wish to comply with New York's guidance in terms of extreme heat. And there's also a recommendation to write out potential illnesses that an employee can experience when they're subjected to extreme heat, like dehydration, potentially cardiac incidents, heat stroke, things like that. And then additionally, in terms of a potential policy, is a recommended heat alchemization procedure where an employee who is now being subjected to 80 degrees on the heat index, 80 degrees or higher, is provided with 2 hours of normal work intensity. And then for the remaining 6 hours, they're actually provided only with light duty work due to the heat. So for the first 20 to 25% of their workday, because it's their first time being exposed to this temperature, they're only working those approximately 2 hours. And then each subsequent day, they're provided an additional 2 hours of normal duty work, with the other half being light duty work until they reach that 100%, which would take approximately 1 week for them now to become adjusted to that higher temperature. And next slide, please. So next is exposure to extreme precipitation, which would be rain and snow. Very similar set of steps here. We have the allow for rest and relief, provide more frequent breaks depending on the temperature and their exposure to something like extreme rain, modifying work schedules if you can change the day of a project to avoid the most extreme precipitation, including things like extreme hurricane force winds or tropical storm. Protective equipment, that'll depend on whether it's rain or snow. So that could be ice cleats, insulated boots, waterproof boots, ensuring that any work equipment has adhesive attached to the handle so that they're non-slip, and that would be useful for both extreme precipitation, both rain and snow. Develop and provide training, so signs and symptoms of cold weather exposure, understanding what frostbite looks like, what hypothermia looks like, and informing your employees of what those potential illnesses, how they happen. Next, having those procedures in writing so that the employees can refer to them, including the supervisors who can identify when an employee might be experiencing those symptoms. And they have additional recommendations in terms of a written policy, like having a buddy system so an employee is never left alone during these extreme weather events, having a specified emergency response plan. So if you have an employee who is suffering from hypothermia or frostbite, there's a very detailed step-by-step plan for how you're going to respond to that weather-related illness, including having specific emergency response units you're able to contact for that employee. Having a two-way communication system, so this could be something like walkie-talkies, and it's very likely Many employers already have these kinds of systems in place, especially in 2024. You most certainly have the phone numbers of most, if not all, your employees or potential foremen who you can contact. But this is so if there is an extreme weather event, or the extreme weather event is changing suddenly, where it's more dangerous than it was previously, you can contact your employees and notify them of the rest and relief options that they have, or if it's severe enough, canceling the entire project for that day as needed. And next is protection from wildfire smokes. I think this is especially timely given that in New York and New Jersey, we've had some wildfires recently, a brush fire in Prospect Park, I think just about 2 weeks ago now. Same 3 steps: relief and rest. So removing employees from those hazardous situations, if that's possible. We're using another index here. It's the air quality index. And if it exceeds 150, that's when certain measures should be taken, like increased breaks and less strenuous work during those poor air quality events. And if the air quality index exceeds 300, employees should be, if possible, removed from the work location entirely. Again, you're going to develop a policy and train your employees on those policies. So identifying potential illnesses that could be related to exposure to harmful air quality, that could be asthma-related events, cardiac events, or stroke. So what are the signs and symptoms of those illnesses? Inform your employees of them, inform your supervisors of them, and then finally is to develop that written plan. And as previously mentioned, this is for before, during, and after all of these events. So for extreme heat, extreme precipitation, and extreme exposure to wildfire smoke, what is the plan in advance of the wildfire smoke? How are we going to respond if the air quality appears to be degrading? If the air quality degrades suddenly during work, what are our options? What is the plan? And if the air quality plan that we instituted seemed effective or was lacking in some way, how are we going to revise it? And additional relief options could be the provision of something like N95 masks, which is probably something that employers might not be doing now and would be unique in terms of complying with this guideline should you wish to do so. You might have a roofing company, for example, and you don't typically provide your employees with an N95 mask because they don't need it. They're not necessarily exposed to hazardous material or air quality that warrants it. But given the recent wildfires and a possible decrease in air quality, it might be beneficial to provide them with that so they can continue to work during those poor air quality events without suffering any negative health impacts. Next slide, please. So what is the impact on employers and what are the recommendations from New York here? As I mentioned, there is no mandate here. It is a recommendation on the part of the Department of Labor, but certainly these guidelines might track future legislation. It might be toned down before it actually becomes law, but we might see similar language, certainly in earlier drafts, where the DOL is pushing for these items to become law. An easy recommendation, if you wish to comply, would be to consider monitoring the National Weather Service, which is a specific recommendation from the Department of Labor in terms of complying with all of these weather-related events. They believe it has the best and most accurate source of information and that it's readily available and should be utilized not only in drafting those initial policies, but sort of actively on the field. Foremen, supervisors should be reviewing the weather events, the air quality, and being able to implement and make sort of real-time decisions about the health of their employees. And then if it appears that the situation might be unsafe or that they need to implement some of the rest and relief measures, that they do so. And understand what the potential cost would be for complying with these obligations. If you don't traditionally provide your employees with N95 masks, but the recent increase in wildfires is now a concern, what is the actual cost in providing your employees with N95 masks? What is the cost? What are the potential delays in construction or the completion of a project if now instead of working a traditional 8-hour shift, employees are working less frequently because they need to take a full 15-minute paid break to decrease their exposure to extreme heat, for example? How might that impact your potential budgeting for these projects? And I think that's it for me.
Well, thank you very much. And as you point out, Patrick, these are points of guidance which may or may not end up in legislation, but to the extent we are in an environment where there are things like wildfires, it would be prudent for those who are tuning in to take heed of these guidelines, because it may end up that ultimately we see some legislation around this. So thank you very much for bringing everybody up to speed. And let's move to our final presenter for the afternoon, and that's Kim Walcott-Gray. Kim will be presenting under my supervision. Kim is yet another native New Yorker who spent her high school years in Queens, and we are delighted that Kim has been with our firm for a period where she's done wonderful work, passed the bar, and soon will be fully licensed, and in the interim has some interesting guidance to share with all of us on Federal Department of Labor coercive contractual provisions. What'll be really interesting, as Kim and I discussed in preparing for this, is how a changing federal government will or will not enforce these standards, but we thought it was useful for all of you to be familiar with them, and from Kim's presentation, I'm confident that will be the case. So Kim, welcome to the program. Kim is on as a first-time presenter, but we are confident it will be among many, and we're delighted to have you.
Thank you, Gabe, for having me and for that great introduction. And to our attendees, thank you for being here today and for tuning in. Kathy, thank you for your assistance with the slides. So as Gabe mentioned, I'll be presenting on the Department of Labor's 2024 Enforcement Report on Coercive Contractual Provisions. Kathy, next slide, please. So the Department of Labor, they provide guidance on 7 different types of provisions that it deems coercive. I will briefly touch upon those provisions and then go over the consequences of using those provisions in contracting. And then I will provide key takeaways for employers. Next slide, please. The first provision is the waiver of statutory protection provision. And these are provisions that require workers to waive their rights to benefits such as minimum wage, overtime pay, or other statutory protections. And examples of these include provisions purporting to waive workers' rights to bring claims or recover damages under the Fair Labor Standards Act, or provisions requiring workers to agree to a shortened statute of limitations period to bring claims under the Fair Labor Standards Act. The law states that a worker's rights to benefits such as minimum wage, overtime pay, and liquidated damages under the Fair Labor Standards Act cannot be abridged or waived by a private agreement. Next slide, please. Next, we have misclassification clauses, and these are provisions that incorrectly classify employees as independent contractors so that employers could avoid legal obligations owed to the employees. The Department of Labor has long held that a contractual provision stating that a worker is either an independent contractor or an employee is not determinative of whether that employee is actually, or that worker, is actually an employee or independent contractor. Instead, the worker's classification depends on the economic realities of the worker's relationship with the employer, which courts assess based on a number of factors that I do not touch upon in this presentation. Next slide, please. Next, we have the indemnification clauses, and these are provisions that seek to shift workers' liability for the cost of the employer's own violations of employment laws. And examples of these include clauses requiring workers to reimburse the employer for costs such as attorney's fees or any other costs associated with defending against claim by the worker, and also clauses requiring workers to cover any back wages and damages that the employer would have to pay due to its violations. So courts have held that employers cannot seek indemnification or a contribution under the Fair Labor Standards Act by shifting their liability to workers or any other individual. Next slide, please. Then we have loser pays clauses, and these are provisions requiring the workers to pay the employer's attorney's fees and costs if the employer prevails in a claim in an employment dispute. The Fair Labor Standards Act has a one-way fee shifting provision, which allows a worker who wins against an employer to obtain an award of attorney's fees, but the same is not true for the employer, meaning that employers cannot recover attorney's fees from workers if the employer prevails in the action. Next slide, please. Then we have stay or pay clauses, And these are provisions requiring workers to pay their employers if they quit before a designated period of time. And examples include employers attempting to hold workers liable for the cost of replacing them, or holding them liable for lost profits, attorney's fees, or the cost of training their replacements. The Department of Labor and other courts have established that employers are generally not entitled to recover these types of costs from employees, and they have been classified as unlawful kickbacks. Next slide, please. Then we have certain types of confidentiality, non-disclosure, and non-disparagement clauses. And the specific type at issue are the broadly worded confidentiality, non-disclosure, and non-disparagement provisions that workers may interpret as preventing them from reporting employment-related issues to the Department of Labor. These type of provisions have been deemed to chill workers' communications with the Department of Labor and are unenforceable if structured in that way. Next slide, please. Lastly, we have internal reporting provisions, and these are provisions that prevent workers from reporting safety concerns or other issues to government agencies before bringing them to the employer. The Solicitor of Labor and the Occupational Safety and Health Administration have taken a stance against employer retaliation for reporting safety concerns directly to government agencies. Next, please. So those are the different types of provisions that the Department of Labor has classified as coercive, and including them in contracting could lead to things such as lawsuits and other enforcement actions by the Department of Labor. It could also, lead to reputation damage and affect employee morale. But as Gabe mentioned in the introduction, with the incoming administration, it may change the way these provisions are enforced. Next, please. So the key takeaway for employers is that it's important to work with legal counsel to draft employment agreements, to avoid potentially coercive language, and to also review your existing agreements for potentially coercive language and bring any concerns to your legal counsel, and also to promote an environment that fosters transparency and where employees will feel safe to report certain types of issues without fear of retaliation. And also with the incoming administration, it is important to stay abreast of new developments that may impact the way these provisions are enforced. Thank you so much for your time.
Kim, thank you for your thoughtful presentation, and please do come on the program come 2025 if there are key changes in this area or others related. We're really appreciative of the commentary you provided today. And so with that, we've concluded our program. It looks like there's a question or two in the chat that we'll do our best to answer in the moments we have remaining. Otherwise, we will get to it in the coming days, as we always do. I know that on the next slide, there's some program notes, which I wanted to make sure to walk you through. First, we're planning for a special program on December 10th, which will be 2 weeks from now. Exciting news, Adam Mastroleo will be guest hosting back on the program. And in the program, there'll be coverage of potential labor and employment changes that follow the federal election. So stay tuned for that, and please do look for additional notices from us as we get closer. Also, as we did last year, just please be aware that on Christmas Eve and New Year's Eve, we won't be having programming. Those are both Tuesdays. So we know that most of you will be with loved ones or otherwise occupied, and we want to make sure that these programs are at times that make sense for all of you. So what we will do instead is skip those weeks, and we will, as we did to start 2024, as we move into early 2025, do some more peering ahead and, with our best gaze trying to determine what is in stock for 2025. So look for more detail on that programming, again, as we advance into December. But in the meanwhile, you have on the slide in front of you the details on all of today's presenters. If you have any questions, reach out. Of course, we are eager to be of help. And above all else, we wanted to wish you all a safe and joyful Thanksgiving holiday. Please make the most of it, and the bond team looks forward to seeing you all in December.